Good day, everyone. And first and foremost, happy 2025 and welcome to the Williams HR Law 2024 HR Law Year in Review and Trends to Watch for 2025. We look forward to this every year for a number of reasons, including we we're very committed to keeping organizations up to date in the very kind of dynamic world of HR law. And importantly for us too, as practitioners, it's a time for us to reflect, take stock on everything that's happened, and just for us to, not take for granted a lot of the boots on the ground experience that we have as practitioners, which give us a the ability to help you to forecast and navigate all that is forever changing in the realm of HR law. And as with the last few years, 2024 did not disappoint. It's been laden with developments. And as it has been for the last few years, people management issues have topped the charts in terms of what a lot of businesses have been focusing on functionally for the last few years. And it's interesting for us always because we work very intensely in the HR realm. And for years, pre-pandemic in particular, HR issues was kind of an afterthought for a lot of organizations, and being very engaged in and involved in HR education through the HRPA, et cetera. We've for years ago, we were always talking about HR not having a seat at the table. Well, we're in a time now where organizations have been calling HR and people management issues, as I said before, have been leading the charge, calling organizations to be strategic, intentional, and proactive. And it's so important when you're making decisions, when things are so constantly changing, to keep your ear to the ground and your fingers on the pulse of what's happening in this realm. So with that in mind, we're happy as always to deliver this webinar to you. And it's our aim to provide you with information and insights this year and always for you to help you to grab the reins as you navigate the dynamic terrain of HR law. So without further ado, I do want to introduce you to members of my highly esteemed team who will be presenting today. Many of you who are joining will be familiar with my partner, Joel Smith. Joel is going to walk us through a number of developments that I'm going to share in a moment. And I'm happy to announce, yes, many of you do know Alexander Pressey as well, but Alex is now a partner as of January 1, 2025. So we are pleased and proud to also debut this to many of you who may have missed it. So just so that I don't take up any time away from the always ambitious kind of scope of content that we've planned, let's do a quick run through of what we've cooked up to discuss with you today. So here is our roadmap. We're going to cover some key developments in the areas of human rights, harassment and off-duty misconduct, sale of business, terminations of employment, and we're going to focus on clauses and conduct, pay transparency and pay equity, legislative updates, and oh, there have been many. And then what we're going to do is unpack some of the key insights in kind of a moderated fireside chat where we'll discuss the trends for 2025, the things that you have to keep on your radar. So as you hear the content, as we present the developments, please, put your questions in the chat, in the Q&A. Actually, we're going to use the Q&A for that. And as they occur to you, because we are going to leave some time at the end where we're going to also field the questions that you have. And also remember that all of what we're going to cover and more is featured in our Year in Review newsletter, which many of you have received. And just to also put on your radar, we're going to release an updated version because we're always committed to issuing the newsletter at the close of the year. And at the close of the year, the legislators snuck in some additional developments that we're going to cover today, but we want to make sure that we capture in our newsletter. So Without further ado, Joel, turning it to you to kick us off.
Thank you, Laura, and thank you to all of the attendees for joining us today. I'm really excited to cover some of the big topics that Laura just referred to there as we start off our webinar. Before we get into it, I do want to truly say thank you to the attendees. I know that a lot of law firms do these now. We've been doing this for many years. I know a lot of other firms are doing this as well. We really appreciate that you come and you spend your time with us. We really work hard to make sure that we're getting you the right insights and the best insights so you can get started on your year. And one more thing that I want to just note before I dive into my content is congratulations as well to Alex. I'm very excited to welcome Alex to the partnership as well. So the first topic that I'm going to cover, as Laura just mentioned, is human rights. So this is accommodation, this is discrimination. Accommodation, as I'm sure everybody here who's here with us today knows, continues to be among the toughest issues for employers and HR professionals to manage. Employees are increasingly comfortable requesting accommodations. The stigmas are getting lower and lower, fortunately, societally, around a lot of disabilities, especially mental health disabilities. And so what does that mean? Employers are dealing with more and more accommodation requests and accommodation requirements every year, again, particularly when it comes to mental health. Now, when we're getting into accommodation issues, as part of their duty to cooperate with the employer in meeting their own obligations, employees generally do have this obligation to provide relevant information to help employers determine what's a reasonable accommodation. And so that's one of the hot topics that we've seen some developments in 2024 to help employers really understand, where are the lines, what are your obligations, and what do your employees have to do in that accommodation process as well. Another one of the key topics that I know a lot of employers are still dealing with when it comes to accommodation is work from home accommodation requests. A lot of employees got comfortable with working from home during the pandemic, during shutdowns and what have you. And so what has that led to? A lot more requests by employees who are already now back to work in part, back to the office in part or in full. Those requests to be accommodated by working from home, sometimes permanently, and their doctors are supporting that. We're seeing more and more medical notes from doctors just saying this person needs to be working from home indefinitely, when that's not what the job is anymore. And so employers have to deal with that, and it's been an ongoing challenge. I know for I'm sure many of you here with me today. I'm sure I've spoken to many of you individually about these issues as well, because I know I've talked to dozens and dozens of clients about these types of issues over the last few years. When employers are dealing with those, they should be requesting medical documentation to determine, whether a work from home request is really necessary, and where the limitations don't require working from home. That's one of those things where, like we're going to talk about more in just a moment, employers don't need to permit the employee to work from home. You should consider and be flexible around other issues, other implications that you can consider when it comes to these employees' accommodation needs. Perhaps the issue is that those employees might just need other accommodations while at work. Maybe it's accommodations in how they get to work. Maybe it's accommodations in their workplace, in their workspace at the office. There's all sorts of different things that can come into play. And again, employees have that duty to cooperate on their end as well. And so without further ado, I do want to dive into these developments so you can really take those into account and consider how can you implement these when you're dealing with these types of situations, work from home accommodation requests and otherwise in your workplace. So like I mentioned, a number of decisions last year did really illustrate this requirement that employees have to request accommodations in many cases and participate in the accommodation process themselves. And so there are three cases that I want to touch on that really help illustrate this point for employers. And again, this is one of those years where I can say happily that there's some encouraging decisions, because I know a lot of the time as employment lawyers, we're saying to our clients, we're saying to attendees to these webinars that there's employee-friendly decisions. These ones do provide some encouragement for employers, and so they're important to bear in mind. In the first decision that we've referenced there, it's a Human Rights Tribunal of Ontario decision called Leeson. And in that decision, the adjudicator found that the employer's duty was not triggered, the duty to accommodate was not triggered, because the employee had failed to request accommodation or otherwise engage in the accommodation process. And so in that case, the employee in question had suffered a concussion at work, and that led to a medical leave. And then upon returning, there were issues with absences and communication issues between the employee and the employer. Ultimately, the employee was not scheduled any longer on the schedule. In this case, the employee asked for some time off for a doctor's appointment, and then went off for that appointment, and then suddenly said she wasn't going to come back to work. But then, somewhat oddly for the employer, A few months later, the employee filed a human rights application saying that the employer had discriminated against her and had actually reprised against her for requesting accommodation. Um, and that was the reason why her employment had ended. In this case, the employer defended itself and the tribunal took the employer's side. They said that in this case, the employee hadn't actually formally requested accommodation, and there wasn't any circumstance that gave rise to the employer's duty to inquire in this case, where employers in some cases do have to inquire into whether an employee might need accommodation based on what they're observing themselves. So those didn't arise here. And the employee didn't provide any medical information to justify any further absences. And so in that case, the tribunal said there's no evidence that the employer failed to accommodate or discriminated against the employee. And so that's, again, one of those circumstances where it's really important as an employer. You want to be asking your employees for the information that you need to be able to accommodate. Now, another key issue that, this is not a new development in the law, but it's encouraging to see the adjudicators reiterating this point. In 2024, the HRTO also came out with this decision called Aguele. And in that case, the HRTO reiterated the point that employees are entitled to reasonable accommodation, not perfect or preferred accommodation. And so in that case, the employer had proposed some accommodations to the employee, and the employee turned those down. And so when the employee brought a human rights claim, the employer was found to have acted appropriately, and they did not discriminate against that employee. In that case, the employee was looking for some preferred shifts, didn't want to work the shifts that the employer was requiring them to work. They claimed that it was related to their childcare obligations at home, but they didn't actually tell the employer that at the time when they were rejecting the shifts that they were being offered and the accommodations that the employer reasonably offered. And so, again, at the end of the day, the tribunal said this employer offered accommodations for an employee, and the employee turned those down, and there was no valid reason. They were reasonable accommodations, and so the employee wasn't entitled to their preference. And so the employer had acted appropriately, had not violated the law. And so that's a really helpful development, again, for employers. Now, with that said, I do want to just highlight employers aren't always going to be off the hook. In the last case that I've mentioned there, Thunder Bay Electronics, in that case, an employee had been on a medical leave, and then just hours after they came back from work, the employee was dismissed. And so in that case, the court had awarded, among other things, $50,000 in aggravated damages because of the employer's conduct in dismissing the employee in that circumstance. And so again, that's just another reminder, 50 grand on top of, the usual termination entitlements that all employees would otherwise have. That's significant, and it really shows you the cost that as an employer, you want to take these things seriously. There's one other human rights issue that I want to cover fairly quickly here because it really was a hot topic last year and continues to be now, and that's political expression. So employers should be aware of the human rights implications and the harassment related implications of political expression because those can really complicate and limit their employer's ability to take corrective action. This was something that we saw a lot last year in light of some of the conflicts that we saw worldwide that really raised a lot of political and religious issues among employees. I'm sure many of you dealt with these last year. I certainly spoke to many of you about these things last year. And so, when these things arise, employers need to make sure that they understand their obligations because this is tricky terrain. So when it comes to political expression, employers need to be aware of what the legislative obligations are. In Ontario, the Human Rights Code does not protect employees' political beliefs as a protected human rights ground. That's different from many other provinces, for example, British Columbia, where political belief is specifically protected. And so for those of you, and I know many of you are here, who have operations across the country, you need to be mindful of the specific legislative obligations in your jurisdiction to know, what's protected and what's not. Human rights isn't the only way that political expression can come up, though. The other way that political expression can find its way into the workplace and employment law is through harassment. So across the country, we now have harassment-related obligations under occupational health and safety legislation. And what we saw last year was a decision where an adjudicator found that, when it comes to political expression, the way that somebody expresses themselves when it comes to their political beliefs can amount to harassment. And so employers need to be mindful of that in dealing with these issues. So that case that I'm talking about is on the screen there. It's the Mount Royal decision. And so in that case, a professor was accused of harassment related to her conduct on social media. This involved a Twitter war between colleagues. The colleagues of this professor filed workplace harassment complaints against the professor in question, and there was an external investigation that was conducted by the employer. The investigators in that case found that simply expressing controversial or provocative opinions, that doesn't constitute harassment, but the manner in which these beliefs are expressed can be harassment. And in this case, in fact, it did amount to harassment. And so the union grieved in that case, and the arbitrator agreed with the reports and found that the type of conduct, that the type of comment that somebody is making and how they express themselves, like tone, for example, is a really important factor in determining whether something is actually harassing. And so again, this is a crucial thing to bear in mind when it comes to political beliefs. Be wary of that in the workplace. So, what are the takeaways here from the human rights segment of the presentation? I've got a few, and I'll go through these quickly because we've got lots to cover. First of all, accommodation requires collaboration. Those cases that I spoke to really illustrate that point. Employers and employees have to work together when it comes to accommodation, and if your employees aren't working together with you, you may have some opportunities to address that. Although you may want to get advice in doing that. Um, when it comes to accommodation, reasonable accommodation is the standard, not perfect, not preferred accommodation, like I was just saying. So bear that in mind. And so if there's an accommodation that you can offer to the employee that works much better operationally and is reasonable, just even though it's not what the employee prefers, you have the right as an employer to implement that accommodation proposal. In addition to that, you want to make sure you're documenting your accommodation efforts. Those cases that I just spoke about, facts were central to those cases. And so the adjudicators really looked at, what happened, who said what at what times. And the best way that you can show that you acted appropriately is document live and, while these things are going on, and make sure that you keep records of the steps that you take in the accommodation process. In addition to that, you want to make sure that you're proactive with your workplace policies. Ensure that you have policies not just about harassment, not just about human rights, but also, when it comes to social media use, off-duty conduct, which I'll talk about more in just a moment, to ensure that you prevent conflicts, especially when it comes to these political expression conflicts that can arise. Now, when issues do arise and you need to investigate, make sure that you investigate with care. When it comes to political expression, for example, these are really tricky issues to understand, what's harassment, what's a human rights violation, what's just a policy violation, and what's fair game in the workplace. This can be really tricky legally. This is something that as investigators we do as a firm, and it's something that we certainly would encourage you to ensure that your investigators who are looking into these really complicated issues are well equipped to do that. And finally, handle your discipline with care. Make sure that you're tying discipline to policy violations. This is especially the case when it comes to political expression issues. If you're disciplining somebody for the way that they expressed a political belief, make sure that it's clear what you're disciplining for. Typically, it's going to be for harassment or for a policy breach rather than discipline for their political belief, which is what they might otherwise assume you're doing. And so that's a good segue as I'm starting to talk about harassment to our next segment here, which is all about harassment and off-duty misconduct. So workplace harassment, it continues to take up so much of HR professionals' time. I don't know where all that time comes from because I just said human rights takes up a lot of the time. Harassment does the same, and I know there's a lot of other things that you're doing on a day-to-day basis as well. Political expression is just one of the many instances where harassment can come up in the workplace and that we continue to see our clients deal with. So another area that harassment often comes up is off-duty conduct. We're seeing cases, and we saw a major case last year that I'll speak about, that relates to conduct that originates outside the workplace. Often it involves online and off-duty behavior. And so, these types of circumstances really raise that question for employers. What obligations do you have when it comes to off-duty conduct? And what steps can you take to address employees, off-duty behavior to ensure that you can avoid issues bleeding into the workplace? Well, again, as I mentioned, there was a helpful decision last year that really helps to illustrate these obligations. So employers have an obligation to investigate employee conduct that impacts the workplace, even when the conduct itself occurred away from the workplace, outside of work. This is particularly the case with the rise of social media, digital communications, what have you. And so the case I'm referring to is a case involving Metrolinx. This started as an arbitration decision, as it's a unionized workplace, that led to a judicial review decision from the court. And so in that case, there was a group of employees who had a WhatsApp group chat, and they made sexist, derogatory comments about another employee in that chat. And so that led to the employer, who found out about it through unrelated channels, there was a different investigation. Somebody mentioned this in passing during one of the interviews in that investigation, and the employer looked into it. The employee who was actually being spoken about actually didn't want to participate, didn't want an investigation to be done, but the employer did the investigation anyway, in line with what they understood to be their obligations. And so after investigating, they dismissed the employees in question. When this was grieved and went to arbitration, the arbitrator took the employee's side, said, this is outside of work, and the complainant didn't even want you to investigate, so it wasn't proper to dismiss these people. The employer sought a judicial review up to the courts of that arbitrator's decision, and the courts took the employer's side. They said that in a circumstance like this, where there's off-duty conduct that does impact the workplace, employers, particularly in Ontario, have a legislative obligation to investigate under the Occupational Health and Safety Act. So that legislative obligation that I was referring to before to investigate harassment issues, that is triggered even when it comes to off-duty conduct that bleeds into the workplace. And that obligation is still in existence, whether or not the employee impacted actually wants to bring a complaint. And so that's still relevant for the employer to investigate. And so in that case, the court referred it back to another arbitrator to consider the decision again, given that this obligation was in fact triggered for the employer. Now, when employers are conducting these investigations, particularly again, Ontario employers conducting Ontario-based workplace harassment investigations, there was some guidance that we got last year from the Ontario Labor Relations Board that's really helpful for you to understand. So in a case involving Stelco earlier in 2024, the Ontario Labor Relations Board dealt with a decision where an employee had brought a complaint, a workplace investigation was conducted into that employee's complaint, and then at the end of the investigation, the employer provided a letter to the complainant setting out effectively what had happened. But it was a pretty thin letter. It didn't say a lot in this case. And so many of you will likely know that at the end of a workplace harassment investigation in Ontario, the Occupational Health and Safety Act requires that employers provide a findings letter to the participants, the complainant and the respondent, in writing. And that needs to let them know what the findings were and any corrective action that was taken. But exactly what that means has been a bit of a gray area for the past few years since the legislative obligations came into effect late last decade, until we got this decision from the Labor Relations Board, who really helped confirm exactly what those letters need to say and what they don't need to say. And so in that case, the Ontario Labor Relations Board, they've clarified that employers are required to identify whether each employee who's accused of harassment, if there's multiple of them, each specific employee, whether or not they harassed the employee. So whether there's a finding that they harassed, but the employer's findings letter does not need to say what specific actions amounted to harassment. That's not required for these letters. More broadly, employers don't also have to provide their entire investigation report to the investigation participants, which has been our interpretation since these legislative obligations came into effect. So that was confirmed by this case as well. And finally, when it comes to corrective action, those letters do have to indicate the form of corrective action that's imposed. But if that corrective action is discipline, they don't need to say exactly what kind of discipline. It was sufficient for the letter just to say that there's discipline that's being imposed. And so, again, these are new clarifications for employers. It's really helpful for you to keep in mind. So what does that decision and those decisions, what do those mean for you as employers moving forward into 2025, dealing with what I'm sure will be more harassment and other off-duty conduct related investigations? Investigations need to be conducted promptly, including when it involves off-duty conduct, and those need to be reasonable in the circumstances. Consider the circumstances and consider if it's off-duty conduct that did impact the workplace to determine if that investigation obligation is triggered. Make sure your policies and procedures are in place and effective. In particular, make sure that it's clear, what type of off-duty conduct might need to be investigated, and make sure it's also clear in your policies or procedures what type of information needs to go into those findings letters, and those should be reviewed in the wake of that Stelco decision that I talked about to make sure that you're giving the right information and you're not giving more than you need to where that might create liability for you. And finally, be mindful of privacy, especially when it comes to off-duty conduct issues. There are privacy requirements that will kick in that we'll talk about a little bit of those more later on, but there are privacy implications that can kick in for employees. And so, you need to be careful not to overly track your employees' off-duty behavior and actions, because that can run into privacy issues for you as an employer. All right, so that takes me to the third segment that I'm going to cover before I pass it over to Alex to take through some more developments. And this is all about sales of business. in 2024, we saw a couple of really helpful decisions that really help illustrate the legal implications for employers who are involved in a sale of all of a business or part of a business. And so I just want to first of all level set for everybody. When it comes to sales of businesses, there's two main types of sales from a legal perspective, from an employment law perspective. There's an asset sale where the buyer purchases certain assets from the seller, and there's a share sale where the entire share of the entire business, as a going concern, is sold to the purchaser. These are treated very differently from an employment law perspective. In an asset sale, where employees were employed by one company, but then as part of the asset sale, they would become employed by another company, the employment relationship doesn't automatically transfer to the buyer. And so I'll talk about more in just a moment, but the buyer has an opportunity to determine whether or not they're going to hire those employees, and they do have the opportunity as well to implement new employment agreements when that sale happens to ensure that they're comfortable with the terms of employment. In a share sale, there's no opportunity for new employment agreements unless the employees agree and consideration is given to them for agreeing to those new employment agreements. Because in a share sale, the owner of the company changes, but the company itself, the employer itself, doesn't change. It just is sold as a going concern, and the employees just flow with the sale automatically. And so this is something we deal with all the time. And unfortunately, oftentimes the employment law implications of a sale of business are the last thing that people think about. They talk to the purchaser or seller, they talk to their corporate lawyers, but they don't think about employment law until, a couple days before closing. And that often is too late to make sure that you're best protected. And so, you always want to make sure you're reaching out for advice. And so the cases I was referring to from last year, one is this case involving ASCO Manufacturing. And in that case, the company was purchased as a going concern. So this is one of those share sales that I was talking about. An employee, was impacted by this sale, and so their employment was transferred over to the buyer. And then the buyer placed that employee on a layoff just a few weeks after the purchase. In that case, the employee brought a constructive dismissal claim saying the layoff amounted to termination, and that was upheld by the court. And the court actually awarded this employee 12 months of notice based on the whole service with both the buyer and the seller. Entirely, because again, the employment relationship just transferred directly over to the buyer. And so even though the employee had only worked for a few weeks with the buyer was on the hook for a year of compensation to that employee. And so again, you want to be careful how your sales are set up. The other case I wanted to refer to is this case involving Brown and General Electric. And so that involved, on the other hand, an asset sale. So in this case, there was a sale of business. The employee didn't automatically transfer to the purchaser, but they were offered employment with the purchaser and they turned it down. And so in that case, the employee brought a wrongful dismissal claim against the seller, their original employer, and they said that their employment was dismissed. And the court said, yes, your employment was dismissed, but the buyer had offered you substantially similar terms of employment and you turned those down. And so you failed to mitigate by trying to replace your income by accepting that job with the other company, with the purchaser. And so that greatly reduced the employer's liability when it came to the termination and the wrongful dismissal action. And so what does this mean for you as employers? A couple of things that are really key. Make sure that you're clearly communicating these changes to your workforce and where employees are impacted by a sale. Consider how to communicate that. Consider if new employment agreements might be required to ensure that you're best protected. And something that you can also consider proactively, even before you're involved with a sale of a business or a purchase of a business, consider including terms in your contracts that give you the right to change who the employer is, so that you can just transfer that employment relationship in some circumstances right over to the purchaser. And again, I said this at the outset, you always want to be seeking advice when you're going through these situations, not just from corporate counsel who are going to help you with your purchase and sale agreement that you're going to enter into, but also from your employment lawyers to make sure that the relationship is set up in a way that best protects you from an employment law perspective. Because although a sale of business is largely corporate, the biggest liability, the biggest cost is often the people. And so the liabilities can be huge. All right, so with that, I'm going to ask Alex to come on and chat with you about terminations of employment.
Thanks, Joel. I do want to take just a couple of seconds. I know Laura and Joel have already said it, but just to say thank you to all those of you who are joining us. And I think it's early enough in 2025 that I can say Happy New Year and thanks for kicking it off with us. And I do also want to say thanks so much to Laura and Joel for your kind words. I'm very excited to have joined the partnership and very, very excited to be part of our amazing team here. And that leaves me with absolutely no segue, so I'm just going to dive right into the developments in the law and things to look out for when it comes to terminations of employment. And so, as you will have seen on the agenda, we're looking at two pieces here, clauses and also conduct when it comes to terminations of employment. So to start off with, I want to chat briefly about enforcing termination provisions. And just to level set, I know those of you who are frequent readers and attendees will know this, but it's just important to consider again that employees in Ontario and really in Canada have two different entitlements. They have that coexist together. Entitlements to common law reasonable notice when it comes to termination of employment, and also statutory entitlements that tend to be much narrower. Common law reasonable notice in Ontario tends to be up to 2 years, sometimes more than the 24 months in exceptional circumstances. Under the ESA, employees are entitled to a maximum of 8 weeks notice, plus for severance employers, those with over $2.5 million in terms of payroll, employees may receive an additional week per year of service up to an additional 26 weeks. So still much, much less than the 24 months. And so having these enforceable termination clauses, as you all know, is quite important. The challenge for employers is that it seems to really be a moving target. Frequently, we've seen over the years employers being frustrated and wondering, well, what's the point in having termination clauses reviewed or having written employment agreements at all when it seems like the law is changing all the time. And we acknowledge that it is frustrating, but it is important to keep up. And there are a lot of success stories that you don't really hear about too much, so I am going to highlight those for you as well. We're going to start with the challenge, though. And the big challenge of this year was the decision in Dufaux and the Corporation of the Township of Ignace. This is something that we spoke about a lot in the spring because in this case, the court struck down a termination clause because it suggested that the employer could dismiss an employee at any time and for any reason. And in essence, it was found that this could potentially be problematic because it could allow employers to dismiss even in very limited circumstances where the Employment Standards Act doesn't permit them to do so, such as in reprisal for taking a leave. This wasn't the intent of the language, but when courts look at the termination clauses, what they're doing is saying, okay, is there any reasonable interpretation in which this clause could be found to be unenforceable? And so this was problematic because this was fairly typical language in a lot of termination clauses because it was intended to provide employers with discretion about when and how they intended to terminate employment. And this decision was actually appealed, and the decision in that appeal was released just at the end of the year, December 19th. Ultimately, the Court of Appeal upheld the decision and upheld it on different grounds than exactly what was in this particular decision. So really what's happened is the law is at the status quo where it was, nothing has changed. This decision and a previous decision that was, our landmark a little while ago, the Waxdale decision, which referred to, what happens when you have unenforceable pieces of a termination clause that, perhaps your without cause clause is enforceable, but there's a with cause provision that is unenforceable. Both of those remain law as they are. And so what this really means is that if employers haven't had an opportunity to update their clauses recently since these decisions came out, they would be very well advised to do so. And one of the sort of bright sides and success stories that I want to point out for you is the other decision that we have on the slide here, Birch and Data Stealth, because this one stands for the proposition that a carefully drafted and updated termination clause with clear language will be held to be enforceable. In this particular situation, the Ontario Superior Court enforced a termination provision that limited the employee's entitlements on termination to the ESA minimums. So this employee was employed for 8.5 months, so not quite a year. The employee was entitled to 1 week's notice under the ESA and the employment agreement and was offered 4 weeks pay in lieu of notice at the end of the employment relationship, so more than the entitlement. The employee came back and claimed wrongful dismissal and claimed 12 months notice, which isn't atypical of short service senior employees, this would have been an entitlement of about $300,000. So, quite a big number. The parties in this case agreed on the facts. There was no dispute related to the facts of the termination, what happened. There were no additional allegations or complicating factors like what Joel was discussing, in terms of potential claims of harassment or, human rights violations. It was just about the language of the clause. So because the parties agreed on the facts, this was decided by way of a motion. The decision was just about the law. And the court found that the clause was unambiguous. There was no reasonable interpretation by which it could be found to be unenforceable. The other thing that's really important to note about this case is that it happened fast. So the termination of employment was June 7th of last year. The lawsuit was commenced very shortly thereafter, but the motion was heard on October 7th. So just a few months later, and the decision was issued October 8th, the next day. So this wasn't a protracted kind of issue, less legal fees than if it had been a long, extended litigation process as well. And the other bright side that I do want to point out to you is often it doesn't even get this far. We've had quite a few cases that we've dealt with where, an employer is looking to terminate employment. We review the agreement. The clause is enforceable. We provide them with advice to offer, something more than the Employment Standards Act minimums or whatever is guaranteed in the clause if it's something higher in exchange for a release, and the employee signs, and that's it. And we've also had situations in which, an employee goes and challenges the decision, and we write back to opposing counsel and say, well, actually, there's no basis for this. The clause is enforceable, and they don't pursue the case. So we do have quite a bit of information about these cases and similar decisions on our blog. I do encourage you to take a look at them. And the next piece that I want to talk about briefly is the conduct component when it comes to terminations of employment. So we've seen courts increasingly recognizing the importance of the duty of good faith. This includes the importance of conducting terminations and, the end of an employment relationship in good faith as well, because there can be significant costs associated with behaving in bad faith. And there are two particular cases that we wanted to draw to your attention from the last year. Again, I won't go into them in a huge amount of detail. We have written about them in detail on our blog. But the first is Clinton Pentax, which is actually a British Columbia decision. In this case, again, the employee had an enforceable termination clause in the employment agreement, so positive from that perspective. But in this case, the employer's conduct actually ended up voiding that enforceable termination clause. The employer ended up requiring the employee to sign a release and implied that the entitlements under his contract that he was supposed to get were going to be contingent on that release, even though he was entitled to them anyway. And really, you can just make a release or additional payments beyond the contractual entitlements contingent on a release. So in this case, the employee would have been entitled to quite a bit anyway, because he had an enhanced termination clause, would have been entitled to about 18 months, but the compensation was going to be calculated in a particular way based on certain formulas that were included in the employment agreement, and the British Columbia Supreme Court ultimately found that the employer's conduct after the dismissal repudiated the employment agreement. The employer was exploiting the employee's uncertainty. They were trying to extract some concessions that just benefited the employer. And as a result, the, as I said, termination clause was invalidated. The employer ended up paying quite a bit more than they would have otherwise. And the court also awarded $25,000 in bad faith damages. The other example that we have here, Koshman and Control X Corp, very different set of circumstances. In this case, it was about defamatory remarks about an employee towards the end of and at the end of the employment relationship. And again, if you're interested, I do encourage you to read the blog. It's a very interesting case. But in essence, what happened here was that the president of the company sadly had passed away and was replaced by his spouse. Once she took on the job, she started making comments about the employee in question, a VP. She started taking his duties away, She took away his signing authority. She directed his subordinates and his clients to deal with her instead of him. And she made comments about him, such as that he was bizarrely involved in her husband's passing, that he was no good, that he was dishonest, that he took kickbacks, all these sorts of things. Ultimately, at the end of this whole process, the court awarded both aggravated damages for bad faith conduct and punitive damages, which are intended to punish an employer when they behaved quite badly, of $50,000 each. So the court found in this case that he was entitled to $100,000 in damages. This was on top of the 24 months notice that he got and approximately $200,000 in legal fees that he received. So over $750,000 in costs. And so where that leaves us in terms of takeaways is, as I've mentioned, it's really important to review and update termination clauses. It's not futile. Courts definitely have not consistently upheld termination clauses, but the ones that are enforceable do get upheld. And ideally, if they're enforceable, you never get to litigation in the first place. It's also important to make sure that you're acting in good faith throughout the termination process, because doing so can cause significant complications and ultimately lead to significant damages. And to help you stay on track, it's often helpful to use a script or a checklist. So when we're assisting employers in terminations of employment, we often prepare talking points that include, here's what you want to cover, and here's what you don't say. Sometimes it includes a more or less choose your own adventure FAQ. If the employee asks this, you should say this, but here are the things, to not address so that it doesn't become a bigger problem later on. And so with that, I do want to make a pretty big shift. So we're going to talk briefly about pay transparency and pay equity. And I'm just going to briefly talk about this here because it's going to show up in a couple of other things that we're going to be talking about today. But what's important to note here is that there has been an increased focus on pay transparency and pay equity. And this is partially driven by, the prevalence of discourse on this topic, the ease with which employees can access information about their own compensation, market compensation, the discussions in social media about pay equity and fairness and all of those things. And so there's been some confusion when it comes to pay equity requirements because there are new ones coming into place for federally regulated employers. We're going to talk about that a little bit more later. But for the vast majority of Ontario employers, Ontario's Pay Equity Act became law in 1987. So it's been around for a while. And it applies to all Ontario public and private sector employees with 10 or more employees. So that hasn't changed. It has been brought more into the forefront. But with respect to pay transparency, there have been some developments there. And so just to briefly touch on this, pay transparency refers to the requirement to openly share compensation information. Pay equity is intended to address systemic gender wage gaps based on job classes, not individual employees, different types of work, different jobs that are considered to be more traditionally female work versus male work. And so really what I want to say here at this point is that pay transparency and pay equity and all the discourse that's been happening here is an opportunity. Employers can use these things as strategies to attract and retain talent by showcasing how they're paying, showcasing their compensation strategies and models, and building trust with their employees. So this, making sure that you're doing this allows you to address concerns about fair pay. It allows employees to see their potential growth in the company. It helps you reduce turnover. And pay transparency also provides an opportunity to proactively show compliance with other related laws like, pay equity. If you're already doing some work to be in compliance with the new pay transparency requirements, you can draw on the other things that you may have done or work that you may be doing in the pay equity area to show employees where you're at. And all of these things can be very beneficial. From a takeaway perspective, just related to this, pardon me, what you should keep in mind is the benefit of conducting an internal review. So assessing your compensation policies and practices before implementing any sort of pay transparency requirement is necessary so you can identify issues. You know, has there been wage compression that you've experienced because minimum wages have changed? Have there been any pay practices? You know, have there been ad hoc hires when you really needed a position and you were willing to pay a little bit more than maybe you historically have, and now the market has shifted? And conducting an internal review also allows you to ensure that your talent acquisition people, you know, other HR people, your hiring managers are all aware of the new requirements that are coming that I'm going to set out in more detail in just a second, and that they're aware of any plans that you have about how you're going to be addressing pay transparency, pay equity, and equal pay for equal work issues in your organization so that you don't find that, you know, you have this great plan and then all of a sudden something has derailed because your frontline people managers who may be involved in your hiring are making offers or making commitments that you aren't able to stand by. And so when you're dealing with these issues, you also want to make sure that you're communicating your compliance. If you've met requirements with respect to pay transparency, be open about it. But also, if you have done the work to ensure that there's equal pay for female job classes in your workplace, then you want to make sure that you put that on blast because it's something that's very important to employees these days. And when you're looking at these issues, you want to make sure that you're capturing compensation comprehensively. Nice little alliteration for you there. So you want to make sure you're not just considering base salary, but bonuses, commissions, any additional benefits. All of these things have to be clearly considered when you're doing evaluation so that you're actually comparing apples to apples. And this brings us to our last topic that we're going to cover in this way. As part of our year in review, you all know we track legislative updates. Now, it has been a time, as has already been mentioned. There's been a lot of activity in HR law, really in the last 10 years, but I would still say this last year has been pretty exceptional. In Ontario, we've had 3 Working for Workers Acts this just last year in 2024. And just to make it a little bit more digestible, we've tried to make it a little bit more fun for you and us, and we're going to walk through the developments visually by date, not by act. So we've got 3 little timelines for you here. Our first one is the timeline of, I suppose, legislative updates passed. And so we're going to look at 2024. And I think it's just taking its time to show, there we go. So we're going to start back in March of 2024 because this is when the Working for Workers 4 Act received royal assent. And again, in the interest of getting through some of these key things, I'm just going to pull out a couple of the key items here to discuss. And if you have any other questions, you're all welcome to reach out, put your questions in the Q&A box here, or take a look at our newsletter and blog that outline these in more detail. But some of the changes that initially came into force in March of 2024, these were focused mostly on the restaurant and hospitality industries, but some of them do impact a lot of other employers as well. The key ones relate to things like the prohibition of unpaid trial periods. So having an employee come in for a shift to try them out and then not pay them, can't do that anymore. The focus here was also on making sure that there were no deductions from wages for dine and dash or gas and dash scenarios. But generally, this prompts employees to consider if you are making any sort of deductions from wages, they actually have to be very carefully constructed and planful in order to be allowed. So, something to consider even if you're not in these industries. In June of 2024, again, there were additional requirements that came in with respect to making sure that if you're tip pooling or tip sharing, that these policies are posted, but also that if vacation pay is paid in any way other than a lump sum at the beginning of vacation, and most employers frankly pay it on every paycheck, written agreement is required. So this is another one of those small changes that a lot of employers are not in compliance with, that if you're taking a look at your agreements, your policies, it would be beneficial to make sure that this is tightened up. As of October 1st, 2024, the general minimum wage went up and fines for violating the ESA also went up. So if you're in violation of the Employment Standards Act, the maximum fine for individuals has now increased from $50,000 to $100,000. So it's doubled, gone up quite a bit. And as of October 28th, the Working for Workers 5 Act received royal assent. And this is where a couple of the new developments that have gotten the most press time occurred. So the prohibition on requesting sick notes came into force on October 28th, and this has caused a lot of confusion. The prohibition here is intended to focus on not having employers request sick days or sick notes for the 3 unpaid sick days that are statutorily guaranteed. This doesn't mean you can't request medical information. If an employee is going to be away for more than 3 days, if they're off for a week, if they need to have some sort of long-term accommodation, in all of these circumstances, an employer is allowed to and would likely be well advised to obtain medical information. So this is just something that's important to keep in mind when you're looking at what the purpose of the legislation is, but also how it impacts your day-to-day operations. Another key one here that I'm just going to pull out is that the definition of workplace harassment and workplace sexual harassment changed in the Occupational Health and Safety Act and was expanded to include virtual harassment that occurs through the use or information of communications technology. In essence, this was already the case, but this does demonstrate some of the shift that we're seeing to try to consider technology, our increasingly remote activities and interactions. And then December 19th, 2024, the government passed the Working for Workers 6 Act received royal assent. It had been introduced just 3 weeks earlier on November 27th. So, went through very, very quickly. This included a lot of changes to the Occupational Health and Safety Act, including mandatory minimums in cases where there's a repeat offense that results in a worker's death or serious injury within a 2-year period, mandatory minimums of $500,000. But one of the key things here is, again, the speed at which this legislation went through the legislature. So we're going to move on to quickly look at what is still coming. And so our legislative updates to come start really in June 19th of 2025, where we're looking at the introduction of a long-term unpaid illness-related leave up to 27 weeks for employees unable to perform the duties of their position. This sounds pretty big. In practice, it is not really anything new because if employees needed to have a long leave related to medical issues previously, employers would have been largely prevented from ending the employment relationship, except in certain specific circumstances, because of human rights related requirements. This just makes it clear and codifies it in the Employment Standards Act. As of July of next year, of this year, because now we're in 2025, there's going to be some additional requirements with respect to making it clear what the terms of an employment relationship are. Again, these are things employers largely do anyway, telling the employee where their anticipated work location is, their hours, their pay, and things like that. And then as of January 1st of next year, this is where a lot of those requirements with respect to pay transparency are actually going to be enforced. So they've been talked about for some time now, but effective January 1st, 2026, there are going to be new job posting rules. And this includes making sure that employers are including expected wages or salary ranges for positions that are publicly advertised. And this is for any compensation under $200,000, but there are salary ranges that can exist of up to $50,000. So this means that if, for example, your salary range is $160,000 to $210,000, that would not need to be posted according to these rules. A couple of other key ones that I want to highlight for you is that if AI is used in the process of recruitment, that has to be disclosed. And employers are required to notify candidates within 45 days about whether a hiring decision has been made. Now, exactly how you do this hasn't been specifically communicated. In theory, if 5 days after the interview you wanted to reach out and say, hey, thanks for the interview, we haven't made a decision yet, presumably that would satisfy this requirement. So we'll see if there's, any more clarification, but that's where the law stands right now. And as of yet, we don't know specifically when this is going to come into force, but under the newly passed Working for Workers 6 Act, an unpaid parental leave of up to 16 weeks is going to be available for employees who become parents via surrogacy or adoption. This is expected to align when similar amendments are going to be made to the federal employment insurance program, just as previously when employment insurance allowed for an 18-month period of collecting EI, provincial leaves were amended accordingly to match. This is going to happen likely in tandem as well. We'll keep monitoring and we'll let you know when this actually comes into effect. And then the last timeline that we have for you just very briefly covers the federal updates, which I've already touched on. So the Federal Pay Equity Act actually came into effect at the end of August of 2021, but the last requirements and the deadline to have final pay equity plans communicated was September 3rd of last year. So again, for those of you who are interested in more details about this, we'd be happy to chat with you further about this specifically, or you're welcome to take a look at the detailed blog that we've put together. At the end of September 2024, there were significant changes made to the labor market impact assessments and temporary foreign worker programs. It is anticipated that there could be more changes coming here because the federal government had said there would be an additional review within 90 days. A standing committee has been considering this, but Parliament is now prorogued until the spring, so we will wait and see what, if anything, further happens here. There could be some changes in the trajectory of planned legislation here. And then in June of this year, certain requirements are going to come into force with respect to prohibitions on federally related employers using certain categories of workers as replacement workers during a strike or lockout. So again, quite a few things to keep in mind and lots of things to look forward to in the future. And with that, I want to pass it back over to Laura to move us into our next segment. Sorry.
Ah, there we go. Okay. We've certainly covered a lot. Thank you so much, Joel and Alex. What a time we're in. And we have to spend some time. We thought it was really important this time just to unpack some of the key trends because there are so many things to look out for. And particularly, it's a good jump off point to move from the legislative changes to really appreciate and take some time to discuss the fact that what's trending is we're seeing an unprecedented volume of legislative activity at both the federal and provincial levels. And, as I said from the outset, it's difficult for us as practitioners even to keep up. And then when you add to this the fact that we're on the cusp of a shifting political landscape with potential federal and provincial elections in the spring, there's a lot to take stock of. And it's easy for changes and developments and trends to fall off our radar. So, Alex, I'm going to stick with you and just asking you, can you share your perspectives on some of the most significant upcoming changes? Like what really should employers focus on?
That's a great question, Laura. And, certainly it's hard to keep your focus on all of the moving targets here. But some of the things from a federal perspective, because that's what, is last touching on that we were expecting were developments with respect to privacy legislation, more focus on privacy generally, There were also anticipated changes to the temporary foreign worker program. But again, we have upcoming elections. As you've said, we also have upcoming elections, maybe provincially. That's what has been suggested in the media. So, depending on the results of those elections, things may change. Federally, we were also anticipating some potential changes to the Canada Labour Code. And provincially, it is somewhat hard to say because we have a government that's made a lot of changes and demonstrated that it can do so quickly. It was the Working for Workers 6 Act, you blinked and it was gone. End of November to kind of mid-December, and that's it. And now there are new things in force. So there's definitely talk of more changes to employment standards, potentially some changes to labor standards legislation. But the big takeaway here that, I hope our attendees go away with is that you need to be flexible and you need to be monitoring these things, because constant legal updates mean, constantly having to look at and making sure you've assessed and tried to be proactive when you're reviewing policies and contracts. Talk to a trusted advisor who can give you strategic advice for, okay, not just what's the law right now, but what's probably coming. How can you try to future-proof to the best of your ability?
Absolutely. And the one thing that, has struck me, and I know we talk about all the time, is that the legislative trends suggest that, the government is being a lot more prescriptive in terms of what employers should and shouldn't do, and even codifying things, as you mentioned, for a number of the updates that really were the law anyway. But so it really feels that employers are being micromanaged, and the consequences from a monetary perspective are also going up. But Joel, just over to you, how can employers proactively prepare for this flurry of legislative activity? What should they be doing?
Thanks, Laura. Let me use this opportunity for a small plug for us. Keep an eye on our blog. We're posting blogs every week. For those of you who have seen the newsletter that accompanies this webinar, we link to our blog posts throughout that, and there are many other blogs. We again post them weekly. So keep an eye on that. We're trying to let you know as early as possible when things are coming down the pipe that you need to be aware of. The government doesn't always give you only 3 weeks from when the legislation is tabled to when it actually comes into effect, like they did in December. They snuck that in under the wire. Usually there's a bit more advanced notice, and so if you're keeping an eye on these things, attending webinars like this one, you're going to be able to stay ahead of things. But that's not all. You should also be keeping an eye on party platforms. When we're in periods of political change, like we're seeing right now, as Alex and Laura, you were both speaking about, look at what they're campaigning on. Of course, I think we all know, I'm not going to be completely cynical to say politicians sometimes say things that don't actually come to fruition when they get elected, but they do give you an indication of where they plan to go. And so, watch those changes so that you can really get on top of the changes before they come into effect. Look at how you can get your workplace in compliance with potential changes that are going to come that politicians are talking about.
Absolutely. And one little housekeeping thing, you gave the plug about our blog, but let me just also add, because we've had questions about whether or not the deck is going to be available post-webinar. Absolutely. You'll receive the deck along with the updated newsletter that I mentioned from the outset. So just stay tuned for that. A bit of a gear shift, and something that we definitely have to tackle because it's one of the dominating issues in HR law and just generally for businesses right now, and that's AI. So, while some employers may want to still keep their head in the sand, you have to come to terms with the fact that employees are using it anyway. And so you do need to, put up some guardrails to mitigate risk, but also to leverage the fact that, for most employers and most organizations, you'll be outpaced if you don't get, if you don't really adopt AI that in ways that can create efficiencies and better service. But AI, when it comes to the HR realm, it impacts all stages and phases of the employment life cycle, as we know, from recruiting to performance management and all other areas. And it also raises red flags around discrimination, transparency, and data privacy. So, Alex, I'm going to punt this one your way. What trends do you think employers should really be cognizant of when we're dealing with AI in the workplace?
I think one of the things that we're going to see is increasing efforts to, as you've said, prescribe how it can or cannot be used, the extent to which you're going to have to disclose its use. And we've seen that with respect to the upcoming regulations with respect to hiring and, making sure that you're disclosing when that's going to be used. We've also seen, as I mentioned, from the occupational health and safety perspective, the sneak in about virtual harassment. So we've seen that the law is a little bit behind technology. We know things are happening. It takes legislatures, even when they're moving quickly, time to catch up. So over the next little while, we're expecting to see more robust compliance frameworks, perhaps more mandatory disclosure in other areas outside of hiring. And what's really important for employers to keep their, focus on is that, as you said, Laura, people are using this. Employees are using it, employers are using it, and this can lead to concerns and suspicion. What does it mean for me? What does it mean for my job? What does it mean for future growth? And questions about the data itself. What data is being collected? How is it used? And I mentioned, previously, sometimes we get mix-ups and confusion because of what's happening in the media. And employees are consuming this information, but perhaps not entirely drawing the correct link. We've seen now recently in the last couple of weeks, there's been a lot of media about class actions related to Home Depot disclosing personal information through its receipts. This wasn't an employee issue, but I'm certain employees are looking at it and wondering, okay, well, when my employer is asking me for XYZ, where's that information going? If they're using a Google form, if they're using, AI to assess this, what's happening? And we've seen some attempts to deal with some of these things. The final point that I'm going to make here as a trend is that, we've seen some proposed privacy legislation in Alberta that, if it passes, will be the most stringent privacy requirements we have in the country. We know from experience and, everything we've seen, these things tend to come in waves. One province or two start something, and then a bunch of the other ones get on board because they see kind of where the train is headed.
Absolutely. And that's why it's really important to try to stay ahead of the curve. And just a couple of things that are important just to double down on that you mentioned is it's really important to ensure that when it comes to the work, any type of engagement of vendors, that you're also including in the vendor contracts requirements that they comply with emerging AI regulations, because you don't want in any way be co-opted into any violations that they may make when performing service on your behalf. And the other thing as well, Alex, is just as you said, transparency is key, right? When it comes, employees want to know and should know and ought to know, and in some cases are required to know when AI is being used and how their information is being handled. So lots to say. Listen, we could have done all of this on AI and the implications, but that's just a few nuggets for everyone to bear in mind. And let's shift gears to another area, restrictive covenants, particularly those that involve non-competition and non-solicitation restrictions. Now, these have definitely been in the spotlight. We've seen courts increasingly scrutinize whether the clauses are reasonable and enforceable. So, Joel, to you, what's the current state of play when it comes to restrictive covenants?
So this is a really important one that I think a lot of employers, may not be live to with everything else going on. When it comes to restrictive covenants, I'm sure a lot of you will know, and I certainly have heard from many of my clients, just a couple of years ago, the Ontario ESA and one of these many Working for Workers Acts was amended, and that now says that really only C-suite executives and presidents of companies can be bound by a non-compete. Otherwise, non-competes will be prohibited as a general rule under the Employment Standards Act right off the bat. That's not really a big shift, though. I know that scared a lot of employers. That's not really a big shift because non-competes for the vast majority of employees are not going to be upheld by the courts anyway. Courts generally don't like to enforce these for public policy reasons. They want to encourage, open competition. Now, non-competes aren't the only type of clause that you can use to help protect your your business interests. As an employer, you can also use, of course, confidentiality clauses, NDAs, these types of things that are really helpful to make sure that employees aren't sharing your confidential information with others, but also non-solicitation clauses. Courts don't love these either, I'll admit, but they are willing to enforce them if they are properly drafted and sufficiently narrowly drafted for the right types of employees. And so just last year, there were a couple of big decisions, again, that flew under the radar for many employers where courts did not enforce non-solicitation and non-competition clauses for employers. And so, what does that mean? The courts are staying on that same trend that they'll only enforce these non-solicitation clauses if they are really narrow when it comes to the geographic restriction, as well as the temporal restriction. So the longer the non-solicitation clause impacts the employee after their employment ends, the less likely it's going to be that that'll actually be enforced by the courts. Similarly, the more broadly that non-solicitation clause might apply geographically, the less likely it's going to be that it's enforced. And so the last one, what type of conduct is actually being restricted? So is the employee restricted from soliciting the clients that they deal with for all types of work, even if they went into a totally different industry that isn't competitive with the business? Or is it only, for example, to go much more narrowly, are they only restricted from soliciting that client to perform services specific to the type of services that they were performing for that client while employed by the employer? The latter point much more likely to be enforced than the former. And so, these things are tricky, and employers, they need to make sure that if you're going to leverage these, and they're really valuable to leverage in many circumstances, you need to make sure you're getting advice to keep them narrow enough.
And just a quick follow-up, Joel, how can employers strike the right balance between their interests and just making sure that they're walking the right line?
I don't like to say talk again to your lawyer, but the reality is these need to be customized. Non-solicitation clauses, non-competition clauses that are just in a template and applied across the board for different employees, different positions, different categories of employee are much less likely to hold up to court scrutiny. You really can't take a one-size-fits-all approach. You need to consider the employee's specific role, the specific types of duties that they perform, the relationships that they have with clients, and other related, instances that are specific to that employee to understand what is reasonable to restrict when it comes to this employee's post-employment conduct when it comes to solicitation, while protecting the employer's legitimate business interest, because that's really what the courts care about. What's a legitimate business interest of the employer that's worthy of protection, and what's an unfair restriction on an employee's ability to go work elsewhere?
All right. I'm going to jump to the last question I think is really important for us to canvas. I think it would be beneficial, and that's, listen, employers have spent a lot on people management issues over the past several years. And there are also concerns about our economy, which are now aggravated by, all of the discourse about, Trump's tariffs, which economists fear would have a major impact on our economy. So employers are frankly looking to save costs, and in many cases, this is crucial. So, what can they do? Joel, what would you suggest?
I mean, there are all sorts of things. The most obvious kind of automatic thing that a lot of employers will go to when you're looking to save costs from an HR perspective is headcount, right? Dismissals, permanent layoffs. Of course, that's always going to be an option, and it has its place. It's not the only thing to do, and I think there are a lot of others that I'll want to mention. But if you are looking at reducing headcount, think about what Alex was speaking about earlier. Make sure those termination clauses are solid. Make sure that your terminations are conducted in an appropriate way so you can minimize the cost of those terminations in a reasonable way. Bear in mind, we're not suggesting that you be unfair to employees, because even the bare minimums by legislation for employees in this country, and particularly in Ontario, are very significant. They're quite generous to employees relative to most other jurisdictions really worldwide. And so making sure that you're limiting it where you can and where it's appropriate to will help reduce the cost when you do have to reduce headcount, if that happens. But again, that's not all you want to consider. There's so many others. A big one that a lot of employers aren't live to is trying to reduce your WSIB costs. So, not every employer is required to be covered by the Workers' Compensation, Workers' Safety Insurance Board, WSIB, but most are in Ontario, and most across the country similarly are covered by that type of legislation in their jurisdictions. And so where you are covered by WSIB, a lot of employers just kind of fill out the forms and stick it in a drawer. Whatever the WSIB says, that's fine. The employee files a claim, we file our form, we move on. That's not the best way to do it. At the first instance, you want to understand, are there claims that might not be legitimate? Unfortunately, some employees do take advantage of these things. And so if if there's a claim that's not legitimate, you do have the opportunity to challenge it, but you need to make sure you're on top of it and you have the right information. But it's not only it's not only about challenging claims, it's also when employees are off work for a lengthy period of time because they had a workplace injury, sometimes it's not just about the workplace injury. Sometimes that employee had a pre-existing condition. We see this with back issues all the time, just as one example. Employees have some sort of back issues they've had for years, for decades, then they have some sort of accident at work and it aggravates that. These can sometimes lead to employees being off for years, but in some cases, if they didn't have the pre-existing back issue, it may have only been a few weeks, for example. And so in these types of circumstances, employers do have something available to them called SEEF, Second Injury Enhancement Fund, through the WSIB. And this is a fund where essentially what it means is the WSIB keeps these monies available where if an employee's recovery is worsened by a pre-existing condition unrelated to the workplace accident, then not all of the employee's claims costs will be borne by the employer as they otherwise would be through their WSIB premiums going up. Some of those will be transferred back into this fund. And so this is something that, 10 plus years ago, it was really common. Employers could really take advantage of this. And then the WSIB really tightened its belt when it had some financial issues and really stopped awarding SEEF relief in many cases. They've come back the other way, and they're now willing to award these SEEF awards where appropriate, where someone's workplace injury from before does impact their recovery. And so employers should be looking at that. This is a pretty easy way, honestly, to get some huge cost relief that can really help you at the end of the day that, again, a lot of employers just aren't even aware of. Last one that I'll just really briefly mention, the restrictive covenants that I was just speaking to, right? Leverage those, clients are a huge part of income. And so it's not just about reducing costs, it's also ensuring that your profits are up to par, especially when the economy might be impacting them otherwise. Look at getting those restrictive covenants in place where they're reasonable and make sure that you're protecting your, again, legitimate business interests as a company.
Excellent. Thanks, Joel. Listen, I want to get to everyone's questions, and I think we'll be able to pack them in. You, Alex, because I am going to turn to you just for your quick hit list of the cost containment strategies that you think should be on employers' radars.
I have so many, but I will keep it quick. AI, right? We talked about it. Leverage it. Get familiar with it. Make sure that you are directing where that ship is going instead of being thrown around on the proverbial waves because they're there. But it can be very helpful for you if you're not caught unaware. Policies are the other one that we've talked about. Make sure your expectations are clear. Particularly if you anticipate that you may have issues, if you don't clarify and crystallize them, it's harder later to hold people accountable, initiate discipline if you have to. And I'm really holding myself back because the stories I could tell you where I just thought, oh, if only you tightened up this policy before and told people maybe don't use technology in this way, and then you could have prevented some of the issues. But I digress from my quick hit list. As Joel mentioned, another one that frequently comes across my desk is there's a lot of allegations, discrimination, harassment. There are a lot of investigations. One thing that employers would really benefit from is really building in-house capacity to conduct investigations if you want to be doing investigations internally. I'm not saying all employers need to do that or that all investigations should be done that way, but if you're going to do them, you have to do them right, which means you need training, you need practices, programs, and upskilling in that area. And the final one, I'm going to say for the next little while at least, is pay equity and pay transparency again. Review your compensation plans and strategies and be proactive about it. This is unfortunately an area where I would say many, if not the majority of Ontario employees covered by this legislation are not actually compliant with the circumstances. And as we've seen in our practice, when you are proactively addressing pay equity issues, you have so much more flexibility, so much more time, and it's ultimately way less costly than when you have some sort of complaint and the pay equity office is micromanaging how you're doing it. That is a much, much more complex and costly and fast-paced process, both in terms of dollars that you're going to owe and just the people resources that you have to put into it. So those are, if I'm constrained, that's my quick hit list.
Well, you were constrained, but you covered it. Thanks so much, Alex, and thanks, Joel. Those are great insights. I want to remind you that these trends are discussed in further depth in our newsletter. And also, Joel, Alex, and I are going to be launching a series of, more of strategic talks because we've recognized, even for ourselves, that it's so important to be intentional and staying on top of what's trending. But it's even more intentional to have just that additional kind of set of insights as you make the tough decisions that need to be made as it relates to your people management issues. So stay tuned for that. Also, just picking up on what Alex mentioned, in March, we are going to be conducting an education session on how you can build and shore up your investigation capacity and capabilities in-house. So that's something to stay tuned to or look out for, and we will have information on that to you shortly. But now let's dive into the questions that have been asked of us. And both Joel, you and Alex are under the gun yet again. And I'm going to punt the first one to you, Joel, because it falls within the realm of off-duty conduct. And the question is, can we do anything as an employer when a current employee posts on LinkedIn an elevated job title and job description?
That's an interesting one. Short answer is yes, absolutely. And in my view, you wouldn't be constrained if you don't have a policy that specifically says don't inflate your job title and job description on LinkedIn. You don't need to have that exact language to address it. When it comes to off-duty conduct, something I didn't have time to really get to in the presentation is, off-duty conduct can be addressed not only when it comes to investigations and harassment situations, but more broadly by the employer where it impacts the workplace in other ways. And so if it impacts the employer's reputation, for example, client relationships, relationships with its other employees, what have you, these are some of the things that give the employer the right to address that off-duty conduct. And certainly an employee posting on LinkedIn, in my view, about their job and not being honest about that is the type of thing that an employer could take issue with. And so that might be a disciplinary issue. It might be a coaching issue first if the employee is willing to cooperate and address that to be able to determine what it is. I'd also suggest, as an employer, if you're seeing that, you want to wonder why. Is that employee have one foot out the door and they're trying to inflate their role and their job description to get that something else? Maybe you want to be planning for the next employee in that role as well.
Indeed. Thanks, Joel. This next one, actually, you covered, but I'm going to ask this of Alex. What specific language is needed in the finding letters? Specifically, can we indicate that their allegations were substantiated, partially substantiated, or not substantiated? Is that sufficient to meet the requirements on the basis of the case?
So largely, yes, with respect to the findings portion. So part of what the decision that Joel covered said is you don't have to give them a full catalog of this is exactly what we found. You don't have to tell them, here's the basis on which we reached our conclusions. You do have to tell them, here's what we found. So yeah, the allegations against you were substantiated or largely substantiated or not substantiated, or the allegations against the respondent, your allegations against the respondent. And you have to say if corrective action was implemented. This is a requirement. You don't necessarily have to specify exactly the level of corrective action that it was, because that can have privacy implications, confidentiality implications, but you do have to have that piece in there as well.
All right, Joel, this is to you. Any examples of what language or areas, topics of conversation to avoid in the termination meeting with an employee?
Do I have an hour? Let me go to one significant one that I often see employers misstep. Be careful with giving them the reason for the dismissal. You don't have an obligation generally to tell the employee why you're dismissing them, but you do have an obligation not to be dishonest with them. And so a lot of organizations, a lot of managers, these things are awkward. Nobody likes to dismiss somebody. I'm sure everyone here who's done one would agree. That's not a fun thing to do. And you try to soften it. You want to say it's restructuring, or you want to say that it's something that it maybe isn't really, to try to, protect the employee's ego, make the dismissal meeting go a little bit more easily. If you're not honest about that, that can run into liability. That can run into those kind of bad faith damages that Alex was talking about, that you need to be really careful about. The one other thing that I would suggest, don't get into specific examples of what may have led to the determination, not the broader reason, but specific examples that might end up in an argument with the employee. You want to really avoid that. And employees sometimes will try to initiate those, asking, was it about this? That's not fair. Why would you do that? those scripts that Alex was talking about that we provide to our clients will often say if they ask questions like that, redirect the conversation, because it's really typically not going to be productive, and it can result in the employee framing the meeting in some other way that can result again in those additional damages.
Absolutely. Alex, this it seems to relate to the update around employer prohibition requesting sick notes as in your legislative update session. And the question is, for these leave types rather, so long-term illness, paternity, adoption, can employers request medical?
So with respect to the long-term illness, yeah, absolutely. Like I mentioned, with the exception of those 3 unpaid sick days statutorily, in most other cases, yes, you can request medical. The new adoption leave that's going to be coming wouldn't necessarily be medical information that you're requesting, but you could request reasonable information in the circumstances, an adoption certificate, some official document that shows when that child comes into the employee's care, things like that. But yeah, it's the again, media. Prohibition on sick notes does not mean you cannot request medical information when you need it to fulfill your accommodation obligations and your health and safety obligations. And if you have any questions about that, please, 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 ask, if it's not us, whoever you go to for your strategic and legal advice about that, because that's going to help you make sure that you're not violating other, I would say in some ways, more technical and potentially more costly obligations by trying to stick to this one.
Excellent. Joel, I'm going to send the next one your way, but I didn't say this from the outset, but we always provide the caution and kind of the proviso that our Q&A will not constitute legal advice. I'm going to read you the whole question. I think it sounds a little situational, but it does give we'll just take it as a scenario for the purposes of a question of this nature, which is a question that we field quite often. So the foundational question is, when is a contract employee deemed permanent? That is contract annually renewed over 4.5 years, good performance reviews, continually obtained funding to subsidize programs and partners. The job is posted as a permanent position. Contract employee interviews poorly, position awarded to another candidate. Contract employee expects to train successor. So how much danger or risk does the employer face that contract employee could be deemed permanent by default under the ESA or otherwise?
So as I'm understanding the fact pattern for this scenario, it's an employee with annual fixed term contracts that renew ultimately after 4.5 years. The employee is not successful in getting the permanent position that this contract role turns into. And so, what do you owe that employee essentially is the question. And so, there's 2 different sources of termination entitlements. Alex touched on this earlier. There's the ESA and there's the common law or the contract if the common law is contracted out of properly with an enforceable termination clause. When it comes to the ESA, as soon as a fixed term employee passes that year mark, they're going to be entitled to termination pay, severance pay potentially based on their full period of service with the employer. And so in the situation we're talking about here, we're well past that point, of course, and so that employee would be entitled to statutory termination entitlements based on that 4.5 years of service. When it comes to the common law or a termination clause in a contract, that gets trickier. It really is going to be a case-by-case assessment, but the courts certainly do have a lot of willingness to listen to employees' arguments when it comes to them suggesting, oh, well, really, this was an indefinite term contract. Yeah, I signed these annual contracts, but that was a mere formality. It might have been, oh, I signed the contract after the next year actually started because we all knew it was going to happen, or it's just, nobody even asked about it. It was just, oh yeah, by the way, sign that thing, and it was just a gimme. And in those types of circumstances, courts certainly might, and in many cases will say, this is really an indefinite term contract. And so in those cases where you have that fixed term contract that says, it's only a 1-year term, the employee might be entitled to common law notice, and you probably don't have an enforceable termination clause because the court sees it as an indefinite term relationship. The contract says otherwise. The other risk that you have is that sometimes the courts will award pay for the rest of the fixed term contract when an employee on a fixed term contract is dismissed, and so there can be a lot of liability there. the general principle that I would say, be careful with fixed term contracts, and when they're renewed over and over again, oftentimes it makes more sense to enter into that indefinite term agreement with the termination clauses that Alex talked about.
Thanks, Joel. So, being mindful of time and the value of everyone's time, I want to just, pause here to officially end the webinar. But tell you that we're committed to answering all of the questions. There are 3 more questions we will go through. So for those of you that wish to hang back and hear our responses to these questions and our insights, please feel free to do so. For those of you that may have other things lined up because this was booked for 90 minutes, we thank you so much for taking the time. As Joel said up from the outset, there are lots of shows in town, a lot of other firms that are doing similar programming, and the fact that you took the time to hear from us means a lot. And I hope this was a good value for the time that you spent, because we certainly have been intentional to bring you what is kind of the hottest of hot developments and trends that you need to know to make sure that, again, you can grab the reins from a people management perspective in 2025. Please stay connected. As I said, we're going to be turning out additional programming to help you navigate our times where we have rapid updates and developments happening kind of weekly, monthly, and so again, we thank you and we look forward to staying in touch, and we wish you all the best for 2025. For those of you that are going to hang back, we're going to plow through the last 3 questions. The next one I will send over to you, Alex. Question is, could you please provide recommendations regarding overtime pay? Again, this sounds very specific, but let's just look at the nature of the employment for an occupational therapist who is an employee on a fee-for-services structure. So I guess the question is, whether or not are they independent? Like, how have you structured the relationship? There's more that we would need to know, but let's give kind of some high-level considerations that might be helpful.
Certainly. Well, you've done half the job for me, Laura. We would have to know exactly how this is structured. Is this person an employee? How much of their time are they spending providing services with this particular organization, institution, employer, whatever the case may be? There are a lot of people who provide services like that and hold themselves out to be in business for themselves. They have other clients, they have outside sources of income. Even if they seem to be working what would be more than a part-time workload or close to a full-time workload, there may be other sources of income. And so there's a lot of different pieces that we would have to look at here to actually determine employee status. Is this person an employee? If so, are they working over the threshold of hours such that they're entitled to overtime pay? And what are the policies in place as well? Because you don't necessarily have to pay overtime pay. You can compensate employees with time off, bank time in lieu of overtime pay if you have a written agreement to do so. So there's just a lot of different unknowns here. But in essence, what you want to make sure that you're doing is being intentional when you're structuring relationships. A lot of people want to be in business for themselves until they realize that maybe there are some entitlements they're leaving on the table, and they may in fact actually be employees. You may owe them things like overtime pay, paid vacation, a lot of other things that you might not otherwise think of. So it's really important to take a close look at your employment relationships.
All right. Great insights there. This is the second last question we're going to field. Joel, this one's over to you. Can you speak to employees recording meetings without consent? What's the best practice?
It's a great question. And this is one that comes up a lot. I'm finding coming up more and more. I was literally talking to a client about that earlier this week. It comes up a lot. So employers generally will retain the right to have policies that prohibit this type of behavior, employees recording meetings. It can really create a lot of issues internally when employees feel like their coworkers are recording them. That's this sort of thing that comes up all the time. And it results in a lot of mistrust. Managers might be afraid of their employees who are recording them. They're not able to manage them effectively because they're concerned about, with how this recording will be used against them, what have you. So best practice, certainly in my view, is, implement policies that would restrict that type of conduct. For those employers that are dealing with these situations and you don't have that policy in place yet, that's going to be a lot more case by case and situational. Often you'll be able to, reset expectations with that employee on a one-on-one basis not initially through discipline, but you may be able to work your way to discipline. And again, that's going to be case by case. I would suggest that you get some advice. And I'm not going to say the name, but I'm mindful of who asked the question. I encourage you to give me a shout and we can chat about it if you're dealing with that issue right now. But then certainly thereafter, get those policies in place. And again, I encourage everyone to get those policies in place because it's only becoming a bigger and bigger issue as everyone has a recording device in their pocket.
All right. And Alex, the last one is coming your way. Can you speak to what defines family accommodation? This is a big one to round us up. I have an employee who he needs to travel 2 days a month. We need to travel 2 days a month locally, but she doesn't want to do this because she drops off and picks up her kids. So that's a great scenario for us to walk through what the foundational principles are here. Alex.
So there actually has been some nice clarifying law on family status accommodation recently as well. And, I have to take it back to first principles, some of the things that Joel already covered, but when you're looking at, human rights, right, there are certain obligations that you have in place, no matter what the type of accommodation is, if it's disability related, if it's family status related, the first piece is always to get all the information that you need. And, employees will often come and say, well, here is what I need, and here's the accommodation that I want. And again, as Joel said, they are not entitled necessarily to the perfect accommodation they want. They are entitled to a reasonable accommodation. So in a circumstance like this, you would want to engage in dialogue with the employee to make sure that you have all the information to understand. Is it that there's nobody else to pick up and drop off the kids, or is this a preference? And there's, quite a bit that employees are reasonably expected to do in order to make sure that they're able to fulfill the duties of their position. Just because this is a preference, it doesn't mean that it's something that the employer needs to accommodate. However, employers also need to make sure that they've done, on their end, their due diligence, that they have, again, the policies and practices in place. Because if this employee has never traveled before, this has always been a requirement and it's been waived for a long time, you're in a slightly different situation than if this is something that's always been going on and now circumstances have somewhat changed. So you may have to explore other issues, could the timing of the days be different such that it's easier and, coincides with the schedule? You might need to look at things like, is this actually an integral part of the job? In certain circumstances, you might actually have to accommodate it, but it's very difficult to know because all of these are so fact dependent. So this would be another, this specific situation, I would say, is one that you would want to get advice on. Generally, the formula is make sure that you have your information, take these accommodation requests in good faith. Don't assume that this is somehow unfair or wrong. We don't know everybody's specific circumstances, and not everybody has the capabilities to accommodate some of these things internally. I use the accommodate as a a loose word, not technically legal. So you want to take them in good faith. You want to make sure that you're assessing this and treating this employee's request like any other request, any accommodation, similar to a health piece as well, and assess it carefully, and then determine what's reasonable in the circumstances and go from there.
Alex, Joel, thank you so much for great insights and just for your preparation and being intentional, making sure that we provide the caliber of insights that we strive to year over year. To everyone that's attended, thank you again. And once again, we hope 2025 is an outstanding year for you in every way.